So that one, my lord, I put that file on the flash disk, but not so just about the time I came to the country.
So we are at the point
I don't think that evidence counts as something against me in the deaths of for children because I put it there at the time. About war. Yes, I downloaded it and put it up. No, I was in the country at the time.
Yes.
He told me that he was just a sponsor of that child. But the mother,
Yes, and I flashed this there on. I put the file on the flash disk. In what I thought was the site of them.
Yes.
Really, it was just. I'll contend my lot that was done to appease them, to kind of find a way to keep the peace. I would assure them.
actually asking him that now you are registering at the shall need to do details for our fight.
I'm not interested in fighting myself. My lord, prosecution also presented to court other
Yes.
evidence, exhibits, or whatever we call them, that seem to suggest this. I did this deliberately and with what. But for example, my lord, there was the beheading video searches. The videos about beheadings by ISIS.
Go down to open the gate.
There was also the school searches for children, searches for schools that teach young children.
oludda olwabi lwagenda mu maaso ne luleeta obujulizi nga balaga nti okutta abaana bano nakikola mu bugenderevu, era ne baleeta obujulizi nga flash disk okwali firimu y'entalo mu China. Eyo firimu nali nagiteekako ku flash disk eyo emabega, era nga ndi mu ggwanga lino. Ekitabo ekiriko ekisoma olutalo mu China, naye nga nali ekitabo ekyo nakiteekako ku flash disk eyo emabega nga ndi mu lutalo, nga ndi mu ggwanga lino Uganda. Ekyo tekisonga ku ngeri y'okuttabwa kw'abaana bano aboogerwako, era bategeeza nti nali saagala era nga sirina kigendererwa mu kulwana ntalo, era nga nali wakuwangulwa. Era oludda olwabi lwaleeta obujulizi obulala era mu kikawubange eky'ebizibiti nga bagezaako okulaga nti kino nakikola nga nakigenderera oba nakiteekateeka, okugeza nga vidiyo eza okutemako emiteezo ekyo ekitongole kya ISIS n'okunoonyereza ku masomero. N'okunoonyereza ku masomero g'abaana abato.
So, Okello, when you finish, you will let me know, because like I told you,
Yes.
when you give unsworn statements, nobody interrupts your conversation. So when you're done, you will let me know and we shall stop.
Yes, when I'm done, I will let you know. Okay. So, moving on along. Yes, my lord, the video, the school searches, and almost all the other evidence that suggests, my lord, that I did this very deliberately, was created in the end. I mean, those events happened at a later time when I did in fact make the searches and did those actions, but there was factors that were forcing me. I didn't even do so willingly still then. And then it comes to the conclusion of defense, my lord, that I didn't do any of this actually intentionally. I mean, in the legal sense of the word. As I played to my So to summarize the intentional murder section, we're going to say defense doesn't believe.
You?
Yeah, I don't. Huh? I don't believe that. I did this murder intentionally, as legally defined, and then that's one reason, my lord, why the charges, all the 4 counts, my lord, should not be honored, my lord. So, my Lord, I will explain separately or in a different section how I came to think and act that way. I'll explain how or why I believe I was forced to act that way.
Please proceed and explain. I'm
Now?
writing. Yes.
Yes, shortly. No, it's not going to be very long. The whole defense is very short, but for organization's sake, I think, my Lord, we should just keep the order here. Yes? Okay. So to support this, to support the argument that I didn't do this intentionally as described in this section, we are going to rely on the exhibits that have already been submitted by prosecution. Yeah, and the charge and caution statement, the plain police statement also. So moving on. Here I'm going to in this section, I'm going to describe why I was forced to, how I believe I didn't very willingly make the police statements. Yeah, in this section, I believe I'm just going to describe. It's very short. How I believe that I didn't make the police statements and some of the other evidence that was.
Mr. Okello, that one you said it already, and I have it on record. That you were forced to.
Yeah, I must. I should describe.
That one I already have it on record. You can now give me something else.
Maybe not, my Lord.
Is that all?
No, there's more, but I'd like us to be sure that we have this on record, my Lord.
Yes, we do. You said that the prosecution tendered in a plain statement and a confession that you said that you killed, where you confessed that you killed the children for wealth or for riches.
Yes.
But you were forced to write that statement, and you had no.
I believe that. I believe so. Yeah.
So that one I have it on record.
But I should say here that these are the witnesses I'm going to rely on. And this is the evidence also that I'm going to rely on. That's what I wanted to complete here.
Your witnesses, yesterday we recorded them, and there was a prayer from your lawyers that we shouldn't disclose their identities, and so I don't want you to mention your witnesses.
Okay, my Lord. Moving on. In the next section, my Lord, I'm going to try to show how it seemed unlikely that I could have conceived even an idea like that. And though it doesn't directly support the arguments that I didn't do it, it can indirectly. We believe so, my Lord, that this section could help to support going to say. The defense contends that the accused.
Yourself and what is your defense?
The accused.
You are the accused.
Okay. I'm going to contend that I am a person said to be of generally good moral character, and is also said to be affectionate and kind, and is also very busy, and he's said to be focused on his work, and is very, very hardworking. Some have said that he's fairly prosperous, maybe by Ugandan standards, and resourceful. And in light of this circumstantial evidence, it helps, or it lends credit to the argument, my Lord, that I couldn't even have conceived the idea, and so maybe alternative explanations could be carefully considered. So moving on.
Let her first interpret.
Waliwo ebyali binsindiikiriza okukola naye nga saabikola mu bugenderevu, era sirina kye nakola mu bugenderevu mu kuwumbawumba ku kigendererwa ky'okutta. Sikkiriza nti natta mu bugenderevu, y'ensonga lwaki njagala kooti eno ereme kukkiriza misango gino, era ngenda kunnyonnyola lwaki ndowooza nti nakakibwa oba nasindiikirizibwa okukola ebyakolebwa, era nga okuwagira obujulizi bwange nti saakola byonna bye nakola mu bugenderevu, neesigama ku bizibiti ebyaleetebwa oludda oluwaabi, era ngenda maaso okugamba nti satta baana bano mu bugenderevu, abogerwako abana, era ngamba nti ndi muntu ayogerwako nti nina empisa ennungi, neeyisa bulungi, ndi wa kisa, nkola nnyo era nga ndi wa mugaso nnyo.
Okay. For this circumstantial evidence section, I'm going to complete. I'm going to contend that I had a bright future to look forward to, and I had my parents to look after, and I had what was I thought a very successful business in the making. And so, in light of all of this, my Lord, it would seem unlikely that that I could do something like this. And so, to support this section, I'm going to call it a prosperous life. I'm going to rely on evidence from my dad, testimony from my dad. Testimony from my former landlord, and testimony from the people that leased me land in Noya. Also, on a resume, my Lord, in my resume. Okay, in this section, I'll call it close. It's just also circumstantial evidence. I cannot prove directly, but it's just supporting evidence that could be useful for defense later. And here I can show, maybe it's just circumstantial, maybe it's stronger, but here I try to make an argument, my Lord, that I went into some distress. So this is something difficult for me, not something I voluntarily participated in. And something was happening to me that I wasn't really in control of. And maybe, my Lord, maybe, my Lord, this section also lends credit to the fact that, to the argument, my Lord, that I wasn't very deliberate in killing the children. And maybe, my Lord, the other evidence could show with more certainty that I wasn't very deliberate in the deaths of the 4 children, my Lord. So moving on. Okay.
Nti nayina ebiro eby'omu maaso ebitangaavu, nayina bazadde bange ab'okulabirira, nti nali business man ng'era njolekedde okuyitamu, ng'era n'obulamu bwange bw'omu maaso ndaba nga bulungi. Nina obujulizi obw'okwogerwako obulungi okuva eri taata wange abampangisa ettaka Enyoya, abantu abansemba mu CV yange. Era nagenda mu maaso n'okwennyika mu birowoozo oba n'okuba nga ndi mwennyamivu, era nga kino tekyali kirungi gye ndi, era nga saakola kintu kyonna mu bugenderevu, era nga nali sisobola kwebeera bikolwa byange. Saakigenderera okutta abaana bano abana.
So the section is here. I'm going to say from around mid-January up to sometime mid or late March. I entered an especially distressing period. And so, my Lord, I was contending with certain people that I will describe in a later section. And during this time, by the way, the time frame is only approximate. I really can't remember for how long and the very precise period it began. But I think it was early January to around late March, my Lord. So. So, my Lord, I'm going to say here that certain people, they got my attention, and they eventually, you know, how am I going to put this correct? My Lord, they somehow began to they began to get accountability from me, legitimate or otherwise. They made increasing demands from me. And I noticed, or they made me notice, that they, you know, they had they had all these capabilities. And so, my Lord, they threatened to kill me. They staked out that neighborhood where I live. If you know what stakeout means, it means like they will park a car or just stand there and watch where I'm living. There'll be somebody there the whole time watching me. So yeah, they staked out that Bunga neighborhood. Yeah, they began to demand money, cash from me. And there was people that would follow me. They follow me closely. So, my Lord, during this time, I left my home. I fled from that neighborhood for a long time. I yeah, I left that home, that small single bedroom where I was renting in Bunga, near the trading center. Then I stayed on the street for a while. I lived outside on the street. I didn't want to be in that in that secluded place too much. So I used to sleep on the street, and I didn't go back to the house too much, but that much. I went there only very little, my Lord. So, I didn't do too much. I was just on the run. I was out there always on the run or hiding somewhere. So, my lord, between this period between the January and the March, in the later part, the very late part of this episode, I tried to my lord, I tried to end it some way, somehow. So I tried a few methods. I tried a few ways to I tried a few things, my lord, to bring the whole thing to an end. And I tried to flee. I tried to flee the country. Then, my lord, I tried to I tried to rob a bank. I tried to rob a bank. Yeah. What? What? Then, my lord, I tried, my lord, to kill my brother's family. Yeah, I did. I tried to kill my brother's family.
Makati g'omwezi ogwa January oba ogw'olubereberye okutuuka ku nkomerero y'omwezi ogwokusatu nali mu kiseera kya kwennyika birowoozo era nalina abantu be nali nsika nabo omuguwa nga mu kiseera ekyo sisobola ngeraageranya sijjukira bulungi oba gwali ku ntandika y'omwezi ogwa January okutuuka mu mwezi ogwokusatu waliwo abantu abatandika okubaako bye bankozesa era nga balina embalirira okuva gyendi era balina bye bansaba ebyenjawulo ng'era bingi nakizuula nti balina obusobozi bwonna bantiisatiisa okunzita baalinga bagumba awantu okumpi n'ewange ng'era obudde bwonna bantambulizaako amaaso gye nali mbeera ebbunga era batandika okukanda ssente enkalu era abantu bannondoolanga. Mu kiseera kino nagezaako okudduka era nga nava we nali nsula mu kazigo era akazigo ako ke nali mpangisa ebbunga mu trading center nakaleka ne ntandika okubeera nga nsula bweru ku luguudo era saddangayo eri mu nju yange era naddangayo bbalirirwe era buli ssaawa nalinga nziruka n'okwekweka wakati w'omwezi gwa January n'ogwokusatu nagezaako ebintu ebyenjawulo era nga nagezaako okuba nga nkomekereza ebintu bino. Nagezaako okudduka mu ggwanga, nagezaako okunyagulula banka, nagezaako n'okutta famire ya muganda wange.
Ms. Okello, are you still proceeding?
Yeah. Still reading. Okay. And yes, my lord, that is all for that distress section. For this section, I will rely on evidence from witness testimony. Yeah. Do I need to name witnesses or?
No, you don't name your witnesses. Your lawyers requested that we don't name them.
Okay, fine. We'll see how many witnesses come in. Okay.
Is that all?
No, not yet. Not all of this. This is not all. But we're almost done. Yes, we're almost done. Yes. So this is the last section. I call this section friends. I describe those people, the adversaries that I bumped into and contended with. So I don't know much about them, my lord. It wasn't very often I saw them. Most of them, but some certain types of these people I saw often, but not every type of person in here did I see often, my lord. So, my lord, I'm going to describe a few types of these people in here. It's just three types of them, actually. So I'm going to describe those and some of the interactions I had with them. So some of them seem to be very young men, maybe even teenagers, but not very young. Late teens, my lord. The younger ones, they wore they wore very new clothes, and they would greet me by my first name, "Hey Chris," and just proceed walking. So an encounter with these ones, my lord, it was just they would come from the opposite direction, and we meet along the path, and then they proceed further down as I proceed ahead, and that's the end of the encounter, my lord. Okay, these last two, I don't know what you want to say, Chris. No. Let me just proceed to a second. I'm going to put it that way. These ones, they drove new cars, very new cars. They were very clean all the time and very well polished. They were modern cars, very modern, very recent, recently made cars. And the people that these people that in this category still they were very well groomed. They dressed very smartly. And my lord, they had radios, walkie-talkies. They were my lord. They were very quiet and they had a distinct expression on their face. They were always I don't know how I'm going to describe this, but I could say they were perfectly expressionless. Maybe that's how I mean to describe it. And then, my lord, the last of the category, they seemed like everyday people. I could only begin to think that they were part of the others by my interactions with them.
Could you please repeat the last category?
Yeah, the last category. This is the last of the three. My lord, in this category, I'm going to say that that they were not distinct like the others. They seemed like any other person on the street. There was nothing unusual about them.
Mr. Okello, is that all?
I'm about to finish. And I could only begin to think, my lord, that they were part of the others. Or I could only begin to, my lord, to think that they were all together, or part of the same team by my overall experience with them collectively, my lord. So So, my lord, I think this is also supporting evidence only, and if witness testimony allows, it could support the witness testimony of the main arguments, and the witness testimony supports the truth of this argument too, my lord. As the defense, I contend that these friends, as I put it, had something to do with my actions on the second, my lord. So, closing, my lord, I believe that that the honorable court shouldn't honor the prayer for the murder conviction on the 4 counts because the defense contends that because defense contends that there was is it extenuating some circumstances that forced me to act the way I acted on the second? And my lord, court shouldn't. What? Yeah, court should not honor the charges that were brought on me as filed because my lord, they didn't make and support a good, strong argument that I was deliberate. They didn't make an argument, my lord, that I was deliberate, and they didn't support. They didn't support the argument enough, my lord. And so, my lord, defense contends that our prayer should be granted that the charges as filed should be dropped, my lord. Should not be honored.
Mr. Okello, is that all?
Yes, my lord, that is all.
Thank you very much.
Yeah.
Abalabe benasisinkana ngamba nti nalaba abantu ab'enjawulo ng'era abamu ne basisinkana nga balirirwe, abamu ne basisinkana nga nnyo, abamu era sabasinkanako, naye nga baali babika bisatu benasisinkana, ng'abamu baali bavubuka nga bali mu egyo emyaka egy'ekkumi, ng'era baalinga bambala engoye empya, ng'era baalinga bansinkana nga bwe bansinkana bambuuzaako nga bambuuzaako nga bayogera erinnya lyange erisooka Chris, era nga olumala okumbuuza nga beeyongerayo baavanga gye mba ntunudde nga nabo gye bava nga bambuuzaako nga beeyongerayo makubo gaabwe. Ekika ekyokubiri eky'abantu benasinkana baalinga bavuga emmotoka empya ng'era bambala engoye ennungi nga bavuga emmotoka ezo empya ebika ebipya ebyakafuluma, era abantu bano baalinga bambala bulungi nnyo ng'era batambula balina zi radio call, ng'era baalinga basirifu nnyo n'engeri gye batunula nga yanjawulo. Ekika ekyokusatu ky'abantu benasinkana bo baalabika nga abantu ba bulijjo ng'era tebalina kibaawula ku bantu ba bulijjo. Era ngamba nti emikwano gino gye nasisinkana gyakola kinene ku bikolwa bye nakola nga 2. Nga nzigalawo nsaba kkooti eno ereme kunsingisa misango gino egy'obutemu kuba ngamba nti waliwo bingi ebyetooloolera ku bikolwa byange bye nakolanga ennaku z'omwezi 2. Era kkooti eno nsaba emisango gino egy'okutta eginvunaanibwa ginzigibweko kubanga oludda oluwaabi terwaleeta bujulizi bumala nti nakikola nkigenderedde, era nsaba emisango gino ginzigibweko.
I want us to take a health break of 20 minutes. And when we come back, we shall listen to the evidence of Mr. Okello's witnesses.
Kooti egenda kuwummulamu kumala eddakiika 2 bwe tukomawo tuwulire abajulizi ba Okello.
Coming back at midday.
Tukomawo ku ssaawa 6:30.
Let's get back to our seats.
Witness testify.
Today is 24th.
You sign on it
And silence, please.
sign. You said defense. What is that? Okay.
You write for me another one.
That's one. Z.
Criminal Session Case number 132 of 2026, Uganda versus Okello Onyum.
My Lord, my name is Richard Kumbuga for defense. And the representation is as before. We intend to summon the second witness for defense. However, before he comes, I have an application to make. My Lord, this witness needs protection from you or from this honorable court for purposes of security, his personal security and his family. My Lord, his prayers are that all cameras off, phone is off,
Phones off or cameras on phones?
cameras on phone. So the journalists should not cover him, and he will write down to this honorable court his full particulars on the piece of paper that will be shared by all of the attorneys on both sides. My Lord, if it pleases you, this is the way he wants to dress while he's in court. 1, to put on a mask. And also, may it please you that he gives his testimony while his head is covered with a cape. I pray so, my Lord.
Prosecution, do you have any problem with that?
My Lord, we have no objection to the protection of the personal identities of the defense witness as far as publication of his images is concerned.
Okay, the prayer to protect this witness is granted. The identity of the witness in terms of his names and other personal information shall not be disclosed to the public. The media or any other individuals are prohibited from taking the pictures or photographs of the witness. Their camera should therefore be put off. And the witness is also permitted to testify while wearing a mask and a cape on his head. Mr. Kumbuga, let's have the witness.
Yes, good afternoon, Your Honor.
You're most welcome. Please write your name on some piece of paper. Your name, your age, and your religion, and where you live.
I swear by the Almighty God that the evidence I shall give attaching the matter before court shall be the truth, nothing but the truth. Thank you.
We are here on the matter before court about the death of the children at Ggaba community while they were at school. But before I ask you about that, do you know this person before you?
Yes, I do.
What's his name?
His name is Onyum Christopher Okello.
Be precise.
He's my brother.
It's your brother. Is it same father and mother?
Same father, same mother.
Who is older?
I'm older.
Okay. Before you came to this court, information has been cutting through this evidence about the health status.
My Lord, I object to that line of leading. That's a leading question.
Objection sustained.
My Lord, let me reply to this objection first.
My Lord, he can't overrule court. The court has given a ruling. I don't think it's right for him to continue making submissions on it.
My Lord, if we are to invoke Article 28, okay, tell this court about the challenges about your brother.
That is also leading, my Lord. The witness has not talked about any challenges. My Lord, that would be leading.
My Lord, at this point, look at the evidence of the accused himself. Didn't he talk about the challenges?
Which challenges?
About his mental status.
He said he was distressed between January and March.
Okay. So I want you to talk about that.
About what? Don't lead him. Don't ask leading questions.
My Lord,
You can ask. You know what you can ask that can give
okay,
the
tell us
answer,
about
the
your
answer
brother.
that you want. You know what you can ask that will give
My
you
Lord,
the answer that you want.
my Lord, let him tell us about he knows his brother. From there, I will catch up with other things.
Ask the question.
Sir, can you tell us about your brother before this matter happened?
Before this matter, maybe I'd ask for guidance. Where would I even start? Considering
Kindly, is your brother, you can begin from childhood up to today.
No, Mr. Kumbuga. We are dealing with a 39-year-old man. Are you telling him to start from when he was a child until now? I think you are specifically interested in a few things, so guide him through what you want.
My Lord, I don't know what is happening right now, but the evidence came here in court about the health challenges as faced from 2016 to 2025. But that's the same information that the prosecution doesn't want me to say. It is on court record. So how will I lead him if they don't want me to mention about any evidence on court record?
No, can you ask the questions independent of what is on the record, can you ask and get what you want?
My Lord, I should ask him about what is on court record.
Okay, ask, but if it is out of place or out of order, I will not allow it. Help you?
Mr. Sir,
Yeah, first
evidence
talk to,
came here.
First talk to Mr. Okello, his hand is up.
Can you tell court what you have come tell court?
No, he was summoned as a witness for the accused person. So he did not offer himself to come. You, as the defense lawyer, you should be able to guide him on what the accused person has instructed you to ask him.
My Lord, exactly what we discussed is on court record, and it's not a secret, and that's where I want him to begin from.
Can you ask the question?
Okay. Can you tell court about the health status of your brother?
Please go ahead and answer that question if you know.
In 2020, I got to learn that he had been admitted to Butabika Hospital. And on following up, I wasn't details and eventually went to Butabika directly. And it's at that point that I learned.
Sir, you're going to go slow because we are writing. You said you got to learn that he had been admitted at Butabika, then on following up?
Yes.
Following up, what happened?
So when I followed up, I went physically to Butabika, and it was there that I was able to learn that he had been admitted there following an incident that had happened.
So while he was in that hospital, Tabika, what exactly happened?
I was informed that
By who?
by the medical staff there at the time that he was being held there for because of what had happened. And
What is that?
they did not give me the details at the time of what had happened leading up to him being put at Butabika.
How long did he stay there?
I was there it was about January, and I'm not certain as for how long he had been there. However, I had begun trying to look for him as early as December, the previous one. So I'm not very certain as to how long he had been there.
Okay. That kind of
Okay, we have to take down what he's saying. You're not certain for how long he had been there, but you had started looking for him the December of the previous year.
That is correct.
That would be 19. That would
be 2019.
2019. Okay.
Okay. So what did the doctors tell you?
They informed me that the details of what had transpired and why he was there they could not discuss with me, in spite of me having mentioned that I was the brother.
Avunaanibwa mumanyi era nga ye Onyum Christopher Okello era nga muganda wange tuva maama omu ne taata omu era nga nze mukulu we. Mu mwaka gwa 2020 nakimanyaako nti yali atwaliddwa mu ddwaliro ly'e Butabika era oluvannyuma lw'okulondoola nawe gendayo ku ddwaliro ly'e Butabika era lwe nakizuula nti ddala yali aweereddwa ekitanda eyo mu eddwaliro oluvannyuma lw'ebyo byali biguddewo. Nabuuza abasawo mu ddwaliro eryo okuntegeeza ku biki ebyali biguddewo naye era tebannyonnyola wadde nga nali mmaze okubategeeza nti nali muganda we. Naliyo mu mwezi gwa January era simanyi bbanga lyenkana kiri yali amazeeyo naye nga nze nalina natandika okumunoonya mu Desemba w'omwaka 2019 era bantegeeza nti ebingi ebimukwatako baali tebasobola kubintegeeza wadde nali mbannyonnyodde nti ndi muganda we.
Okay. That challenge that took your brother to Butabika, do you have any history in your family?
Challenge is that?
My Lord, okay.
Because we need to know the history you want.
Much obliged, my Lord. A police surgeon came here that your brother.
I am
My Lord,
I'm constrained. I'm constrained. Not that, my Lord, we want to suppress whatever evidence that our learned brother wants to bring out. But, my Lord, we have rules on how evidence in chief is led so that it comes out naturally from a witness without counsel appearing to suggest the line of answers. My Lord, we pray that we be understood so that we are all at peace.
I agree with you because when Mr. Okello was speaking to us earlier on, he didn't mention anything like that. So he would not be the right person. To talk about it, and when you're using this evidence, so you can.
Honorable Court, your brother's reason that took him to Tabika?
But you see, even the witness said the doctors did not tell him. So we do not know, right now, we do not know what challenge it is, and I think that is what you should be interested in getting.
My Lord, since it has come to the knowledge of court, before even this witness came, let me make this humble application.
You want to make an application in the midst of the evidence of the witness?
Yes, my Lord.
Okay, let's proceed with your application, please.
My Lord, this application is brought under Article 28 of the Constitution, the doctrine of fair hearing. And Section 46 of the Trial on Indictment Act.
Se-
46. My Lord, briefly it states,
No, don't. We shall read, but just what is your prayer or your application?
my application is that the doctors of Tabika should come to this court since from the prosecution evidence it is on record that he was there
Can we please bring the context?
Yes, my Lord.
Please, let's
According to PF 24, my Lord. That he has that history. Under this section 46, there should be an inquiry about the health status of the accused before this honorable court. 2, to come actually tell this court whether it is true the accused has ever been in this hospital for people with mental challenges. I do believe and submit that it is the quest for justice that has brought us here all. This government institution shall be able to tell us in case he was their client at a certain time in life, his health status, and also they will be able to tell us whether as of now is capable of following the proceedings. And to be put on his stand, much as he has finished. Thank you, my Lord.
Do you have a specific doctor you would like the court to call?
My Lord, this information came from both police file during evidence.
No, now you are doing your defense because you have to guide the court. Because if you say, first wait, if you say that I should tell the doctors of Butavika to come, who do I call and who do I leave there?
My Lord,
I need your guidance.
My Lord, if any order is made with the administrative staff of Butavika, they will search for records to find out who exactly dealt with him, and they will be able to address court in case there is that information.
Okay, do you have the time frame, the period that they should look for?
My Lord, in the wisdom of this court, I do not have powers to order Butavika. It will be the court order
I'm
to
asking,
give the
you are
time
the one
frame.
who wants the information, and I'm asking you, I should give an order that is clear.
The order should state whether this person has ever been in Butavika hospital as a client.
Okay, fine. Let me hear from the prosecution if you have any reply.
My Lord, I'm continuing. And which doctor exactly examined? And that in case he's a client, he was a client, they should assign a specific doctor to come and address this honorable court. I pray so, my Lord.
Any reply from the prosecution?
My Lord, can I have about 2 minutes
Please.
to
Please.
be ready? We are ready, my Lord.
Please proceed.
My Lord, we find the application by the defense is strange at this stage. Strange because
You're going to go slow, please.
strange because it is being made in the middle of a defense witness well after the accused has fully given his defense. And without any convincing background arising from the witness on the stand. My Lord, the section 46 of the TIA that is being quoted addresses.
Sir, would you like to see it in the meantime?
Yeah, sure.
Please, you can be seated.
My Lord, that section 46 is concerned with capacity of the accused to stand trial. Or give his defense. And my Lord, for avoidance of doubt, my Lord, allow me to read subsection 1 of section 46. My Lord, in this section it is provided that when in the course of a trial, the High Court has reason to believe that the accused is a person suffering from mental illness and consequently incapable of making his or her defense, it shall inquire into the fact of such mental illness. An application under this section, my Lord, should be brought before the accused's defense. And not after. My Lord, capacity to stand trial has been defined by this High Court before. And you will allow me to persuade your Lordship with the decision of your learned brother, His Lordship, Justice Stephen Mubiru, in miscellaneous criminal application number 9 of 2017. It's a case of Amaka Geoffrey versus Uganda. Where the import of the present section 46, it was 45 then, was interpreted, and the court on page 5 of the ruling held that a person will be found capable of standing trial person will be found capable of standing trial where he is able to do one or more of the following. My Lord, the first is understand the nature or object of the proceedings, in a sense that he is able to understand that he is in a courtroom, in a sense, my Lord, that is able to understand that is in a courtroom, recognize the people in the courtroom, for example, the judge, the state attorney, his advocate, and why they are there. Number 2, understand the possible consequences of the proceedings. The example that is given, my Lord, is to understand what he is charged with, what kind of pleas to enter, and is i.e. guilty or not guilty, if he can understand what can happen to him if he pleads guilty, or what can happen if he does not tell the truth in court. My Lord, the third parameter that is used to assess capacity to stand trial is if the accused is capable of communicating with his advocate, if he's capable of communicating with his advocate in the sense that he is able to take part in his own defense. He is able to take part in his own defense and tell his advocate even in basic terms what he wants to do with his case. My Lord, on page 6 of the ruling, His Lordship further held that the test of fitness to stand trial only requires that a person has basic understanding of their legal problem. That the test is not whether they actually know their legal situation, but whether they are able to understand the concepts involved and to communicate the basic facts about their case. His Lordship further quoted in quoting the authorities of R versus Pritchard. My Lord, Pritchard is Pritchard. It is cited at 173 ER at page 135. Among others, my Lord, he quoted more than that, but my Lord, we are providing the authority to quote. Emphasized that capacity is the central concern. Which means that the bar for determining fitness is actually set quite low. His Lordship emphasized, as provided, my Lord, in the quoted authorities, that there are two separate questions. Whether the accused is able to understand and plead to the indictment against him, whether the accused is able to understand and plead to the indictment against him, and whether he would be able to take an effective part in the trial. And my Lord, the court held further that it is for the court to decide this and not doctors. This question of capacity, my Lord, is for the decision of court, not doctors. And that the medical evidence should be considered as part of the evidence in the case and not as the sole evidence on a freestanding application. Let's provide this already. Counsel, did you get this? So did we pass this copy? Oh, okay, great. So, my Lord,
Mr. The lawyer is making submissions, so let's first give him an opportunity to submit, and if there is anything you may need to communicate, you can communicate it later.
So, my Lord, by subsection 1 of section 46, there are two observations that we want to make. One, that the application is being made belatedly. And so to speak, technical overtaken by events. But my Lord, even if it had been made prior to the commencement of the accused's defense, there is nothing to show on record or even by evidence that the accused before your Lordship is incapable of appreciating any of the set parameters used to determine capacity for standing trial. It is even worse, my Lord, that this application is being made in the middle of a witness, in the middle of a testimony of a witness. In the middle of the testimony of a witness who says he was never availed, and the reasons as to why his brother was in Butabika. So, my Lord, if court is to agree with our position on subsection 1, then subsection 2 will equally be, of section 46 will equally be inapplicable. And even subsection 3, because again, my Lord, let me just read subsection 3. It provides that if as a result of the inquiry, my Lord, subsection 2 is if court has any reason to suspect that the accused is incapable of standing trial, then it can make the inquiry. But under subsection 3, my Lord, if as a result of the inquiry, the court is of opinion that the accused is of an unsound mind and consequently incapable of making his defense, it shall, then the consequences follow, my Lord. So we are submitting that in the absence of any evidence, my Lord, that the accused before you is incapable of following the proceedings of this trial, then this section 46 cannot be invoked. Finally, we want to observe that the prayer from our learned brother for the defense is of a generic nature. Some sort of fishing expedition. It lacks specificity as to what exactly this court should do and in respect of which person. My Lord, if you asked, our honest view is, as we perceive the prayer by the defense, it's a mechanism to sort of look for or fish for evidence that they are not sure about. Secondly, the defense, with due respect, misquotes the import of the information on Police Form 24. As tendered by PW 11 in Prosecution Exhibit 7. The reference to the possibility of the accused ever having been at Butabika, my lord, the witness was clear, was evidence or information given by the accused. It's not a finding of that witness. But most importantly, my lord, again, the defense is seeking to establish, for this court to help them establish whether or not the accused has ever been at a mental health hospital called Butabika. My lord, the legislature never intended that Section 46 be used for purposes other than ascertainment of the current capacity of the accused to follow court proceedings. It was not meant to address matters in the history and with due respect, my lord, the import of this section should not be expanded to address unintended parameters. We therefore submit that the application is misplaced and unsustainable. Not just at this stage, but also in the manner in which it has been raised. We pray that it be dismissed.
Mr. Kumga, do you wish to make any rejoinder?
My lord, this section begins by saying, in the course of trial, the High Court has reason to believe. I will end at that. I go to another point. It also, the backbone of the application was
the whole of it. Can read the whole of it. Subsection 1 of 46.
The High Court has reason to believe that the accused is suffering from mental illness. And consequently incapable of making his or her defense shall inquire into the matter.
Thank you.
My purpose was to bring to the attention of court about the question of law during trial. And the backbone came from the witness that his brother has ever been in this mental facility. So my purpose of bringing this question of law was to uphold the constitutional article 28(1) of fair hearing. But I will be pleased for this honorable court to take any direction.
Is that all?
Yes, my lord.
Okay, I'm standing over this matter to 3 p.m. I got to prepare the ruling on this issue.
Kote eyimiriziddwamu mpaka ku ssaawa 9 ew'ensala yaayo ku kusaba kuweereddwayo.
Check. 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 1, 2. Check. 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 1, 2.
Proceed. Criminal Session Case number 132 of 2026, Uganda versus Christopher Okello Onyum.
Mr. Okello, good afternoon. Okay. Okay, this is the ruling of the court, and it is in respect of an application which came shortly into the evidence of DW2, who testified that he is a biological elder brother of the accused person. He stated that in 2020, he got information that his brother was admitted in Butavika. When he went to check on him in January 2020, he learned that he had been admitted following an incident that had happened. Counsel for the accused did not lead this witness to explain to the court what incident it was. He further testified that he learned from the medical staff at Butavika that he was being held there because of what had happened, but they did not give him reasons. He further testified that he was not certain of how long he had been at Butavika, but he had tried looking for him in December 2019, and they said that they could not discuss any details with him, despite the fact that he had informed them that he was his brother. It was at this point that Mr. Kumbuga Richard, counsel for the accused person, made an application to this court while relying on Article 28 of the Constitution, that's the right to a fair hearing, and Section 46(1) of the Trial on Indictments Act. He asked the court to call the doctors in Butavika because from the evidence on record by the prosecution, it was indicated that the accused had a history of mental illness. He also asked this court to make an inquiry into the mental health of the accused pursuant to Section 46(1) of the Trial on Indictments Act. He further stated that this government institution, that is Butavika, would be in a position to tell us whether the accused has ever been in Butavika in his life and his health status, and they will also be able to tell us whether he's capable of following the proceedings and to be put on his stand, much as he has finished. I need to observe from the onset that I find this application in the middle of the testimony of DW2 with almost no background information, very irregular. I would rather counsel waited for the witness to first give his evidence, whereupon he would have sufficient information upon which to base his application. Nevertheless, I will proceed to address his concerns. In reply, Mr. Jonathan Muwaganya, Chief State Attorney, while citing Section 46(1) of the Trial on Indictments Act, contended that this application is rather strange and was brought too late. He argued that that the provision of the law, that is Section 46(1) of the Trial on Indictments Act, relates to the capacity of the accused person to follow proceedings during trial. He argued that an application under this section should be brought before the accused's defense and not after. While citing the case of Omaka Geoffrey versus Uganda, number 9 of 2017, he submitted that the capacity to stand trial when the person has capacity to stand trial when he is able to do one or more of the following. A, that he understands the nature and consequences of the proceedings, and that he can communicate with his advocate in the sense that he's able to take part in his own defense. He further argued that the two separate questions to ask is whether the accused is able to understand and plead to the indictment against him, and whether he would be able to take an effective part in the trial. He further stated that this was for court to decide and not the doctors. That is from that decision. And now this is the decision of the court. Section 46 of the Trial on Indictment Act is under Part 7, which provides for procedure in case of mental illness or other incapacity of the accused person. Subsection 1 thereof provides that, and I'm quoting, when in the course of a trial, the High Court has reason to believe that the accused is suffering from mental illness and consequently incapable of making his or her defense, it shall inquire into the fact of such mental illness. In the case of Omaka Geoffrey versus Uganda, which the prosecution relied on, I am persuaded by the decision of the Land Honorable Justice Stephen Mubiru regarding what to look at when to determine whether a person is capable or not. He says a person will be capable of standing trial where he is able to do one or more of the following. Understand the nature or object of the proceedings in the sense that he is able to understand that he is in a courtroom, recognize the people in the courtroom, that is the judge, the state attorney, his advocate, and why they are there. 2, understand the possible consequences of the proceedings. That is to understand what he is charged with, what kind of pleas he can take, that he is guilty or not guilty, what can happen to him if he pleads guilty, or what can happen if he does not tell the truth in court. 3, communicate with his advocate in the sense that he is able to take part in his own defense and tell his advocate, even in basic terms, what he wants to do with his case. When this matter first came up on the 13th of April 2026, this court interfaced with the accused person for the first time. I extended my greetings to him and he respectfully responded to me. I informed him that there were some charges against him and I needed to tell him his rights to a fair hearing under Article 28 of the Constitution. I explained to him his right to a presumption of innocence and the right to be legally represented, among others. I informed him that 2 lawyers had been assigned to him to assist him in these proceedings. I also informed him that if he had anything to ask or communicate, he would communicate the same through his lawyers or he would speak to the court directly. I then asked him if he had understood, and he answered in the affirmative. Since then, the accused person has very well exercised those rights, right from the time of taking plea to the time of giving his defense. The accused exercised his right to plead not guilty to all the 4 counts, and in fact, when I first asked him, while explaining to him the particulars of the first count, and I asked him whether it was true, he asked me, "Do you mean my plea?" And when I said yes, he went ahead to say, "I plead not guilty." This pattern followed through the other counts. I have observed him throughout the proceedings, and I am satisfied that he was alert and keenly following the proceedings. Occasionally, whenever he had something to communicate, he often raised his hand, and I would either ask his lawyers to attend to him, and immediately I would ask the lawyers whether they had a communication to make to court from the accused person. However, on other occasions, he raised his hand, and his lawyers would tell me that he wants to address court personally. Whenever I gave him a chance to speak, I did not find anything irregular with his speech, which would have given me reason to believe that he is suffering from mental illness and incapable of following the court proceedings and eventually give his defense. When the prosecution closed its case yesterday, the 23rd of April 2026, and after finding a prima facie case against the accused on all the 4 counts, thereby requiring him to give his defense, I explained to him the options that were available to him to make his defense pursuant to Section 74, subsection 2 of the Trial on Indictments Act. I then asked him if he had understood, and he said that he had understood. I specifically asked the accused person to repeat what he had understood, and he accurately explained it back to me. I gave him 30 minutes to consult with his lawyers and informed the court which option he would take. When court resumed, he informed the court that he wasn't quite ready, but said he would give a sworn testimony. Regarding his witnesses, he informed the court that he needed to get their particulars in his 3 phones, 2 smartphones and 1 button phone, which he clearly described. The same which were already admitted as prosecution exhibits were availed to him, and he was given time to scroll through them, upon which he wrote 4 names and telephone contacts on a piece of paper for court to summon them. I am glad to note that the defense has informed the court that 2 out of the 4 witnesses whose particulars were availed to court were duly summoned and are present in court. The current witness, DW2, who stated that is the accused's brother, being one of them. After the accused informed the court that he would give a sworn testimony, I again gave him an hour to prepare himself. And when court resumed, he still informed the court that he was still not yet prepared to give his defense. I then reminded him that if he gave a sworn testimony, he would be subjected to cross-examination by counsel for the state. And then he responded, in that case, I will give an unsworn statement. The matter was then adjourned today, the 24th day of April 2026, when he gave a detailed and sworn statement. The accused asked whether he could consult his notes while he gave his defense, and his request was granted. He then took out his notes and kept on making reference to them under different subjects. He also occasionally made reference to the evidence of the prosecution and going ahead to rebut it with his own evidence. He repeatedly stated that he did not deliberately kill the 4 children, but he was under the control of some people whom he said were in 3 categories. The accused father stated that between the months of January to March this year, he was in distress as a result of those people who were surveilling him, and he understood that they would prevail over him. I am satisfied that this is his defense, which the court will analyze in light of the other evidence on record at the time of giving judgment. Throughout the trial, it has been, of course, clearly said that the accused person suffers from chronic sickle cell anemia disease, which affects his body. It does not affect his mental abilities. In light of the above, therefore, in the course of this trial, I have had no reason to believe that the accused is suffering from any mental illness, which would make him incapable of making his defense, thus requiring me to inquire into his mental abilities. I have watched the accused throughout the trial, and I'm satisfied that he has been following the proceedings right from the beginning. I therefore decline to make an inquiry into the mental health of the accused person as requested by his lawyers. Counsel for the accused has also asked this court to call the doctors in Butabika. Unfortunately, he did not specify which doctor this court should call. He also stated that the doctor should tell us whether the accused has ever been to Butabika Mental Hospital. Unfortunately, he also did not specify which period. It is important to note that DW2 is the first person to mention that the accused person has ever been in Butabika. The accused person himself, while giving his defense, never mentioned at all that he had ever been in Butabika. The mental distress he talked about while giving his evidence was between the months of January to March 2026. Counsel for the accused made reference to PF24, which was marked as a prosecution exhibit PEX7, That was the examination of the accused person on his physical and mental abilities done on the 7th of April. Those were five days after the alleged offense happened, by Dr. Nwamanya Emmanuel, who is a police surgeon but also a psychiatrist. He informed the court that he assessed the accused person, and these were his findings, and I'm quoting. He had normal behavior, calm, cooperative, speech was coherent, his memory intact, and exhibited good judgment. His thought process and content was normal, but believed in wealth by human sacrifice. He was able to explain the reason for killing the children as fortune hunting or enrichment. He got the idea on recalling childhood folk tales of getting wealth by sacrificing people. In that report, Dr. Nwamanya made a note as information from the accused, and I'm also quoting. He had a history of past mental illness, treated between 2016 to 2025 for schizophrenia associated with both auditory and visual hallucinations. He killed his 2 to 3-year-old brother in 2016 or 2017, reportedly to save him from the troubles of this world. He also attempted suicide in 2023, and he was also a sickle cell patient on treatment. The findings above are suggestive of a mental condition with psychotic episodes. Further mental assessment is necessary since no medical documents were availed, and he was the only source of information. From the above information, Butabika is not mentioned anywhere. The defense has not given this court any information regarding the mental health of the accused person in light of the presumption of sanity under Section 10 of the Penal Code Act, Cap 128. Having said that, I reiterate that the only person that has mentioned that the accused person has ever been to Butabika before this court is DW2. I am unable to make an order requested for by the defense lawyers on behalf of the accused to call a doctor from Butabika before hearing the full testimony of DW2. In the meantime, DW2 shall continue his testimony, whereupon the court will make a decision as whether it is necessary to call somebody from Butabika or not, but it will only be restricted to as to whether the accused person has ever been to Butabika, but not to make an inquiry as to whether he's capable of standing his trial. And that is the order of the court. Can give the summary.
Twawumulidde Puliida Okello yataddeyo okusaba kwe ng'asaba nti kooti ewa ekiragiro, kooti etumye bayite omusawo okuva e Butabika ajje awa obujulizi oba Okello ategeera bulungi oba nedda, era n'omuwabi wa gavumenti n'addamu n'asaba n'agamba okusinziira okusaba we kujjidde akuwakanya n'okuba nti essaawa bye bakuleetedde ng'Okello amaze okuwa obujulizi okuweewozaako kwe, era tewaliiwo na bukakafu buleeteddwa ludda lwawaabirwa, era omulamuzi akyekennenyeza n'ayetegereza n'obujulizi obwaleetebwa edda, n'agamba nti okusinziira n'engeri gy'abadde ayogerezeganyaamu n'Okello okuva omusango we gwatandika nga 13 omwezi guno, tannazuulawo nsonga yonna emwaliriza kubanga anoonyereza ku ntegeera y'Okello. N'agamba nti obujulizi bw'ono omujulizi ow'okubiri ow'oludda olwawaabirwa agende mu maaso n'obujulizi bwe olwaleero.
Sir, would you please resume your stand? Mr. Kumbuga, you know where we stopped?
Thank you, my Lord. Defense has successfully led the defense witness, and we close our evidence in respect of that witness. We pray. Prosecution goes ahead to cross-examine.
You're telling me that was all you needed from him?
No, my Lord, I've said in respect of this witness.
That is all you needed from this witness?
Yes, my Lord.
Okay. Do you have any cross-examination you want to make, counsel for the state?
So I'm going to ask you a few questions. Your brother, I just want you to confirm that your position is that your brother was in Butabika in the year 2020. Is that your position?
Yes, sir.
Tinkakasa nti muganda wange yali mu ddwaliro ly'e Butabika mu mwaka 2020.
But you don't know the reason why he was taken there, do you?
No, the reason was not given to me.
Era ensonga lwaki yatwalibwayo sigimanyi kuba ensonga teyampeebwa.
But it is in your knowledge that before finding himself there, he had killed a stepbrother called Freeman. Is that something in your knowledge?
I have had. It's not something that I would say is in my knowledge.
What have you heard?
I had heard that, as counsel had mentioned, that he had killed the person called Freeman.
Freeman is supposed to be your brother, a son of your biological dad. Do you still want this court to believe that is a fact not in your knowledge?
I had not met my little brother before.
So you are not aware whether he's alive or dead?
I am aware that he is dead.
Nawulira buulize nti nali nkiwuliddeko nti muganda wange ono yatta omuntu ayitibwa Freeman ng'era
And,
nkimanyi nti oyo Freeman yafa.
And from Butabika, as you say, your brother, the accused person, went straight to the United States. Do you know when he went to the US?
No, I do not.
Simanyi ddi muganda wange lwe yagenda mu America.
So other than today, when did you last see the accused person?
Physically, the last I saw him was
Which year?
other than today.
Yes.
Other than today, the last I saw him was in the evening of the night of April 2nd.
Was this after his arrest?
Yes, that was after his arrest.
Ng'oggyeko leero lwe nasemba okulaba muganda wange ono maaso ku maaso namulaba ng'amaze okukwatibwa kawungeezi kanga 2 omwezi ogwokuna.
Okay, other than the night of April 2nd when he was arrested, when had you last seen him?
It had been long, I cannot.
In terms of
recall.
years, can you estimate for this court in terms of years?
About 5-6 years.
Ng'oggyeko olwo akawungeezi k'olwo nga 2 omwezi ogwokuna nali nasemba okulaba muganda wange mu myaka wakati w'5 n'omukaaga emabega.
And I'll be correct to observe that even though you are biological brothers, you are not close associates. You are not close friends. Will my observation be correct?
Yes, that would be correct.
Tiwadde tuli baaluganda naye tetuli nnyo ba mukwano.
Well, finally I'm instructed that actually, okay, before I tell you my instructions, confirm to this court that when your stepbrother Freeman was killed, the accused person was never produced in any court of law for that murder. Do you know that fact?
No.
Was he produced in any court of law, to your knowledge, for that murder?
I do not know that, no.
Ekyo sikimanyiiko oba muganda wange oluvannyuma lw'okuttibwa kwa muto wange Freeman yatwalibwako mu mbuga z'amateeka zonna.
Our second last question with you, sir. You don't actually know under what arrangement your brother was taken to Butabika. Is that correct? You don't know who and under what arrangement he was taken to that place called Butabika.
That is correct.
Kituufu simanyi ani oba ntendera ki mwe baayita okutwala muganda wange Butabika.
In fact, you, as your brother, even when you attempted to go there, you never saw him physically to confirm that he was there. Is that correct?
Okay,
I
the question
did-
is that when you went, did you see him? Did you see your brother?
Yes, I saw him.
You found him there?
Yes.
Bwe nagendayo butabika muganda wange namulaba era namusangayo.
Now, our instructions is that after your brother committed a heinous crime for the murder of Freeman, Butabika was used as a scapegoat, and he was taken there without following due process, and from Butabika, he was whisked out of Uganda. And his presence, his production in Butabika was on purpose to escape the due process. What do you have to say about our instructions?
My Lord, I have something to say about the question.
Please go ahead.
My brother should be clear
I
about
think
the instructions.
Mr. Okello wants to say something. You first attend to him. His hand has been up for quite some time. First hear what he's saying. You don't want him? Who do you want? You want to talk to me? You want to ask me? Please go ahead. Give him a microphone.
Yes, my lord. So, my lord, can I ask the witness any question a question or four, maybe three?
You want to cross-examine your own witness? Mr. Kumbuga, you had an issue with Mr.
My Lord, my humble
Mwanyana's
request is that my land colleague should tell the witness the instructions, then he goes ahead to continue with that question.
I thought he did that. You want the specificity of the instructions.
Yes, then
I actually
he goes
think
ahead to
I
answer.
got the instructions from the question. He says he has instructions that he was taken to Tabika after killing Freeman to escape the due process. And from Butabika, they actually whisked him to the US. That is what I thought he said.
Yes, my Lord, but that's a statement, it's not
Okay,
instructions.
And then he was now going to ask a question. Those were the instructions, and he was going to ask a question.
So, my Lord, I pray that my land colleague gives the instructions he was given, then he goes ahead to answer the question.
Okay. I thought that's what you were doing. Mr. Mwaganya, you have heard? You have instructions. You can now put the question to the witness.
What do you have to say about my said instructions?
You have an answer to the question?
No, I do not have an answer to the question.
My Lord, that's all.
That is all. Any re-exam, Mr. Kumbuga?
No
I
re-exam,
think
my
the
lord.
question that he wanted to ask him, he can give it to you, and then you re-examine the witness. You can go and talk to him. Yes, any re-exam?
My lord is insisting on asking him questions.
No, I will not allow him to cross-examine his own witness because he called him, and that is why you're there. But I have a few questions to ask you, sir. So you say he's your biological brother and you share both parents. Are your parents both still alive?
Yes, both our parents are still alive.
Bazadde baffe be bamu, maama ne taata era bakyali balamu.
Do they live in Uganda?
Yes, they do.
Era babeera mu ggwanga Uganda.
And you said that you last met your brother, the most recent encounter was after his arrest.
Yes, that is correct.
Era kituufu nasemba okusinkana muganda wange ng'amaze okukwatibwa.
But if I can clarify, I saw him. We did not meet.
Namulaba bulabi naye tetwasisinkana.
Where did you see him?
That was at Kabalagala police station.
Nalaba ku police station y'e Kabalagala.
Which date was that?
On the 2nd of April this year.
Baali nga 2 mwezi ogwokuna omwaka guno.
At what time?
I don't remember the exact time, but it was between 8:30 p.m. and 10 p.m.
Sijjukira ssaawa zennyini naye zaali wakati wa 2:00 ez'ekiro ne ssaawa 4 ez'ekiro.
Okay. And how did you end up in Kabalagala?
I had work in Ginger.
Okay, how did you go? Who told you to go to Kabalagala?
I received information that he seemed to be the person they were talking about with this occurrence. And then I went to the police station to confirm.
Tinafuna amawulire alabika ye muntu eyali akoze bino byali bituuseewo era naye ngenda ku poliisi y'e Kabalagala okakasa.
Who gave you the information?
I found out from my wife.
Mawulire gano nagamanyira ku mukyala wange.
And when you reached Kabalaga, you said you didn't meet him, you just saw him, and did you talk?
No, we did not talk.
Natuuka ku poliisi y'e Kabalagala saayogera naye.
Okay. And about this visit in Butabika that you talked about, are you able to remember the date?
The exact date, no. I just remember, the reason I remember is shortly after the visit, then we had the lockdowns.
Sijjukira nnaku za mwezi zennyini naye kyenzijjukira nti oluvannyuma lwanza okugendayo e Butabika ne wajjawo omuggalo.
Okay. So who told you that he was in Butabika?
We were supposed to have had a family meeting, a get-together in December 2019, and during that planning process, I was trying to check with my mother because I couldn't reach him, and that's when I heard that from a friend that maybe, brother, from another brother.
Twali tulina okuba n'olukuŋŋaana nga famire naye mu nteekateeka twalina okuba n'olukuŋŋaana olwo mu Desemba ya 2019 naye okubuuza maama wange.
So that other brother told you what?
When trying to reach him, because during that time he should have also been in touch, and then that's the one who told me that he could be somewhere in Kampala, maybe at the hospital.
Muganda wange omulala bwe twabuuzaganya ye yategeeza nti alina okuba nga ali Kampala ono Okello era nga tebeezebwa okuba nga ali mu ddwaliro.
So when you reached there, who did you talk to?
I had initially tried to meet the admin who was present at the time, and then I was directed to, I think, an in-charge. So she's the one who informed me that that case was sensitive, and I would not be able to meet him.
What did the in-charge tell you?
That the case under which he was brought in was sensitive, and I would not be in position to meet him.
What was sensitive?
Sorry?
The case was sensitive.
Yes, please.
Ntandika nagezaako okwogerezeganya n'abaddukanya eddwaliro eryo ne babaako eyali akulira mu kitundu ekyo essaawa eyo.
You meet him because when he was asking you whether you met him, you said you met him. Did you meet him during that visit?
No, I did not meet him, but while walking in the compound, I was able to see him in one of the wards.
Walking in the compound and then you saw in the ward? It's not clear, sir.
The administration block in order to access the administration block, you literally have to go through the compound, and the wards are on the left and on the right. So I believe it was just chance that I actually got to see him.
Did you talk to him?
No, I did not.
So would you be in a position to tell me with certainty why he was taken to Butabika?
At present, with the information I now know, or at the time?
What did it can be two-way, at the time and now, but we can begin with then.
At the time, I thought maybe he had broken down. I could not ascertain why he was there. And now, largely through hearsay, I have heard maybe the reasons why he was there.
Through hearsay from who? Tell us whether that source we shall determine whether it is credible or not.
Largely through social media and what is being posted online.
No, we don't take social media as evidence. It is not evidence. Okay, so did you ever get to know when he left Butabika?
No, I did not get to know exactly when he left.
And since then, have you met him again apart from the encounter at Kabalagala police station?
No, we have not met since. We have, however, been chatting on phone.
Did you try to ask your parents why he was in Butabika?
No, I did not.
And did they ever tell you why he was in Butabika? You may not have asked them, but for them, did they tell you?
To get context, my mother at present is not one you can have a coordinated discussion with at the moment. So it was not viable. And with my dad, we've had an estranged relationship. So it was not exactly possible to have that kind of conversation.
How many are you? Children, how many are you? Born by your mother and father?
By my biological mother, we are 4 boys.
4 boys. Okay. Let me hear from you, Mr. Jonathan, whether there's anything that arises from my questions.
My Lord, not at all.
How about you, Mr. Kumbuga?
No, my lord.
Okay, I earlier on said that I would make a decision as to whether I need to summon anyone from Butavika after hearing the evidence of DW2. But after hearing his evidence, I have not found it necessary to make an order for any doctor from Butavika to come to court to tell the court whether the accused has ever been in Butavika. As I already noted, the accused himself never ever stated that he has ever been admitted in Butavika. This witness states that the in charge of Butavika informed him that the case under which he was admitted there was sensitive and she couldn't give him any information. The witness himself has not informed this court that he knows his brother, the accused, to have any mental health challenges. It is also my considered view that even if it was believed that the accused was in Butavika in 2020, it would not be of any relevance to this case. This is because this offense is alleged to have happened on 2nd of April 2026, and I've also made a finding that throughout the proceedings, the accused person has been keenly following up the court procedures. I therefore decline to make any order to summon anyone from Butavika. And thank you so much for coming. You can now step down. Let's have your next witness, please. Does this one also need protection? You did not tell us. Okay, cameras off, no images, no pictures for this witness as well. Please give him a piece of paper to write his name. Good afternoon, sir.
Good afternoon.
Okay, you're going to write your name and your age and your religion on that piece of paper.
Teekako amannya go n'ebikwatako byonna.
can let him take off.
Ndayira mu linnya lya Katonda obujulizi bwenda okuba mu kooti ku musango guno gwa mazima atali bulimba.
Okay, please, Mr. Kumuga, take on the witness.
Kindly look at this person here.
Tunuulira omwami oyo atudde awo.
Do you know him?
Omumanyi?
Mumanyi naye mumanyi mu nnaku nga bbiri.
Munaku nga bbiri. So when did you first meet him?
Wamusooka ddi omusisinkana?
Olunaku luno nasooka omusisinkana oyo mwami yajja mu Kisenyi.
Kisenyi of where?
Kisenyi kyawa?
Kisenyi Kampala.
I first met him at Kisenyi in Kampala.
Okay, continue.
Oyo mwami yansanga n'abaana tuli ba street kid.
That man found me with children. We are street kids.
How many were you?
Mwali bameka?
Twali bangi kwa ne mwana tusukamu.
We are many. We are over 40.
Okay, what happened?
Kyo kyaddirira?
Oyo mwami yali ayitawo tumugamba nko gyebaleko naye nga ali muntu wa luzungu.
That gentleman was passing and we greeted him.
Mwami we twamubuuza tumugamba anko batugulire amazzi ga bitaano tunyweko.
He was speaking English and we told him, buy for us some water for drinking.
Oyo mwami n'atugamba tebagera kubawa amazzi bagera kubawa emmere.
That gentleman told us they are not going to give you water, they are going to give you food.
Waliwo omukazi atunda hoteeri atunda emmere etandikira ku 1,000.
There is a lady there who sells food and the prices start at 1,000.
Tumugamba anko
What type of food?
Tunda mmere kika ki?
kawunga na bijanjaalo n'omuceere.
Sells posho, beans and rice.
Tumugamba anko obanga bwoti obadde osazeewo ffe tulina buzibu katwogere ne anti waffe atuwa emmere.
We told him, if that's what you have decided, let's talk with our auntie so that she gives us the food.
Kale omwami we tumuyita tumugamba genda oyogere ne anti olaba tubegera emmere yameka ffe we tuli waneeno zabaana nja kuba organizinga.
I told that gentleman to go and meet and talk with our auntie to see the food she would give us and it's for how much. Me, I would organize the other children.
Nasigala nga nsootinga abaana mbateeka mu layini bagamuteerere.
I remained sorting the other children and lining them up.
Nsootinga abaana ne bampuliriza kubeera bali bampuliriza.
I sorted them and they listened to me because there they listened to me.
Kale anko yajjira nga maze okwesootinga ne anti agamba batule bali batandika babegera emmere mpola mpola.
And that uncle came back after sorting himself with the other auntie and he told us, we sit there and they start serving us the food slowly, slowly.
Atoma tambuze emmere tubagabira emmere tugabanya abaana emmere tugabanya abaana emmere. Emmere olwaggwayo abanko nagamba ali nkwagalamu okwo.
We distributed the food, sharing it amongst all the children, and when it was done, that uncle told me he wanted to talk to me.
Awo yansabira enamba yange y'essimu.
That's when he asked for my phone number.
Mpa ku namba y'essimu ze bwe nabanga nze wano nessangawo baana nja kukubiranga omukole ki onsootingira abaana.
He told me to give him my phone number that whenever he would come and he doesn't find me, he would call me and I help him sort other children.
Okulu olunaku banku n'agenda nga mmulekedde enamba yange y'essimu agamba kuyeetegewo Christopher.
That day he left when I had given him my phone number and he told me to save his and put his name as Christopher.
Nange ne mugamba ku yange nange teekako Sande kuba nali siraba buzibu bwonna.
I also told him to save mine and put the name Sunday.
Olwo olunaku n'agenda
And on that day he left.
n'akomawo enkeera era n'atusangawo n'agamba abaana baliwo ne ndeetawo abaana abaaliwo era kolonero n'atugulira emmere.
The following day he came back. He inquired how many children were around. I checked around and again he bought us food.
N'ajja ne kalita 10 ak'amazzi ag'okunywa.
He came with a 10-liter jerrycan of drinking water.
Yajja ennaku nga 2 awo olunaku olwokusatu saddamu mulabako.
He came for about 2 days and on the third day I didn't see him again.
So you mean from that day you are seeing him right again?
Kyogamba okuva ku olwo ozzeemu kumulaba kati.
N'addamu okumulaba ku mawulire.
I saw him again at the news.
Okay. Do you have anything more to tell this court?
Olinayo ekirala ky'wanditaze okutegeeza kkooti eno?
Nedda.
No.
My Lord, I'm through with this witness. If there is any cross-examination, it's welcome. Much obliged.
Mr. Mwaganya, are you cross-examining this witness?
Just a few questions.
Please go ahead.
Liido ya omuwabi wa gavumenti agenda kubuuzaamu ebibuuzo.
So just for you to confirm, do you know the specific dates when you met Christopher?
Ojjukira ennaku z'omwezi zennyini ze wasinkanamu Christopher.
Like date and month.
Ennaku z'omwezi n'omwezi.
Zaali nga 19 Ogwokubiri.
It was on 19th February.
This year?
Mwaka guno.
Yeah.
And what is the age bracket of the children that you were organizing on his instructions?
Abaana be wali okuŋŋaanya bali mu wakati wa myaka emeka ku emeka byagamba okuŋŋaanya.
Kutandikira ku myaka 7, 8, 10 n'abalinga nze.
Between 7 years, 8 years, 10 years, and those like me.
So finally, I want you to confirm that you don't know where Christopher was after the 19th of February this year.
Kakasa kooti eno nti tomanyi wa Christopher gye yali oluvannyuma lwa 19 omwezi ogwokubiri omwaka guno.
Sitegedde.
Kakasa kooti eno nti tomanyi Christopher gye yadda oluvannyuma lw'ennaku z'omwezi nga 19 omwezi ogwokubiri omwaka guno.
Simanyi.
I don't know.
My Lord, that is all.
Okay. Any re-exam?
No, my Lord.
Yes.
My Lord, I pray for adjournment to summon the remaining 2 witnesses he talked about.
Saba omusango gwe olunaku olulala yitayo abajulizi abalala abayogerwako.
My Lord,
Oh. Thank you so much for coming. You can step down.
Weebale nnyo okujja osobola okugenda.
Mr. Morgan, is that what you wanted to tell me? To discharge the witness, or you wanted to respond to his prayer for adjournment?
yeah, my Lord, I wanted to briefly raise a concern about the prayer for adjournment. My Lord, the order of court was to summon all witnesses as listed by the accused. And no reason has been advanced by the defense why the rest of the witnesses have not been produced. We believe that an adjournment should be on purpose. First, obviously, my Lord, on the relevance which is in the hands of the defense, the relevance of the witnesses. But second, the possibility of the witnesses appearing. We seek for your indulgence, my Lord.
Want to make a rejoinder?
May it please you, my Lord, you read for us where the land chief state attorney gave reasons when we were adjourning, then I will reply.
No, the chief state attorney actually, if you may recall, Mr. Kumbuga, all of us have been here. There was no day that the chief state attorney did not have enough witnesses. If anything, we actually always adjourned and left witnesses unattended to because of time.
My Lord, what deserves on my side, his side also should be deserved. He's asking reasons from me, but I pray that the court record is here. He reads to us that on the following days, I offered the following reasons. That's why witnesses didn't come. Then I reply his statement.
I've actually not understood you, but I think he was trying to say the orders of the court were, he gave us 4 names with numbers, and he was trying to say we had 2 witnesses out of the 4. So why are the 2 not here? But maybe I have an answer. You can sit down and I'll explain. Following the order of the court to serve the 4 witnesses whose identities were not disclosed to the public, efforts were made to serve those witnesses, and those efforts can actually be confirmed by the appearance of the 2 witnesses out of the 4 that he had named. But there is one which number is not a Ugandan number. I have an affidavit of service from Ampaile Evelyn. Ampaile Evelyn is that lady seated there. She says on 23rd she received summons from the deputy registrar to serve a witness named, and then a telephone number. I believe it is like an American telephone number. Then it says, on the same day, 23rd, I tried calling the telephone number using my MTN line in order to reach him for service of summons, but the number was not available. Mr. Kumbuga, I'm responding to you, please listen. That I called the said telephone number several times at 405, at 550, at 558, and all was in vain. That I also tried to send witness summons through WhatsApp, but could not find the said telephone number on WhatsApp. That I swear this affidavit confirmed that that telephone number was unavailable and the witness could not be reached. And so that is for that one. And then the other 2 who were here, she also saw an affidavit to that effect. Then for another one, she says that she received the summons for that particular witness on the particular telephone number, and on the same day she tried calling the telephone number given using her MTN line in order to reach him for his address, but the number was not available. She again tried the same number several times at 401, at 506, and at 5:53 p.m. All those numbers were still, on all those times, the telephone number was still unavailable. But I also sent him witness summons on his WhatsApp, but it was showing that his WhatsApp was last seen on the 15th March 2026. So that is where we are. Efforts were made to summon these 2 witnesses, but unfortunately they could not be reached. I want to believe that if they could be reached, they would have been here, like the other 2 witnesses who came. I want you to again talk with Mr. Christopher Okello, and I can explain that to him, and let him tell us whether he still thinks we give him an opportunity to call these 2 witnesses, but if he can dispense with them, that would also be fine. He should know that efforts to trace and get these numbers were in vain.
My Lord, I pray we approach.
Okay, I have taken note that the accused person yesterday informed the court that he intended to call 4 witnesses. He went ahead to avail their names with their telephone numbers. Unfortunately, he did not avail their physical addresses. So the process server used those telephone numbers, and she was able to get the 2 witnesses who have since testified as DW2 and DW3. However, on the 2 numbers availed by the accused person, according to her affidavits, which she deponed to this morning, which she deponed to yesterday, 23rd, yes, she stated that one of the telephone numbers which was availed by the accused person, it is not a Ugandan number, this is an American number, and she made efforts to reach on this number, the person on this number, but the number was off. She tried at 4:05 p.m., at 5:50 p.m., and at 5:58 p.m., but all was in vain. She then tried to send the witness summons using WhatsApp, but the telephone number was not on WhatsApp. Then for the other witness, there was also no address, but there was a telephone number. She also deponed the affidavit on 23rd, and she also indicated that she tried several times. The first time was at 4:01 p.m., then at 5:06 p.m., and then at 5:53 p.m., but still this number was not going through. Then she sent the witness summons on a WhatsApp of that number, but it showed her that this number had last seen WhatsApp on the 15th of March of 2026. But we all saw that she at least managed to serve 2 witnesses who appeared today. But I will give this accused person one more time to make another effort to try and see whether we shall get to these 2 witnesses. I am asking the Deputy Registrar to again make an effort and ensure that he tries to trace these 2 witnesses. And so for that reason, I am adjourning this case to Monday, the 27th of April, 2026 at 9 a.m. for further defense hearing, and the accused person is further remanded till then.
Omuvunaanwa yategeeza nti yali alina okuyita abajulizi 4 era n'atuwa amannya n'ennamba z'essimu naye nga teyateekako gye babeera, era kooti n'etwala obuvunaanyizibwa n'efuna process server oba atambuza amabaluwa mu kooti n'akuba amasimu ago agamuweereddwa, era ababiri n'abafuna era be bajulizi abazze olwaleero, omujulizi abadde owookubiri ku ludda olwawabirwa n'omujulizi abadde owookusatu ku ludda olwo. N'agezaako okkuba ennamba endala yamuweereddwa nga nnamba ya Amerika, era n'agigezaako enfunda eziwera naye neetayitamu. N'agezaako okusindika obubaka ku mukutu gwa WhatsApp, ennamba neeraga nti teri ku mukutu gwa WhatsApp. N'adda ku nnamba endala era nayo neeraga nti teriiko. N'agiddamu enfunda eziwera era n'agisindikako n'obubaka ku WhatsApp naye neeraga nti yali saawa eyo teri online ng'erudde okubeerako, yakoma mu gwa 3. N'olw'ensonga eyo avunaanibwa aweereddwayo obudde obulala. Omusango ongezeddwayo empaka nga 27 omwezi ogwokuna omwaka guno ku ssaawa 3, era n'Okello osindikiddwa okuddayo ku alimanda okutuusa ku olwo.
Hello, please. Attention, administrative announcement. I request for my interpreter, someone to interpret in Uganda, please. thank you very much for your patience. You have been with us from 13th. We have been here for 2 weeks, isn't it? Yes, we thank you for patience.
Mwebale nnyo olw'obugumiikiriza bwammwe
We thank you for cooperation.
n'obumu.
Now the case has been adjourned
Kati omusango gwongezeddwayo
to Monday
okutuusa ku bbalaza
because the accused still has more witnesses.
kubanga avunaanibwa akyalinayo abajulizi abalala.
He gave us 4 names
Yatuwa
and 4 telephone contacts.
amannya g'abantu 4 n'ennamba z'essimu z'abantu be 4.
We managed to get 2.
Twasobodde kufunako 2.
Other 2 could not be reached. Their phones were not on.
Ababiri abalala baali tebasobola kutuukikako kubanga essimu zaabwe tezaaliko.
That one was explained well by the judge.
Ekyo omulamuzi akinyonyodde bulungi.
But my coming here now
Naye okujja kwange kati wano
is to tell you that on Monday we may not be here.
kwa kubategeeza nti ku bbalaza tuyinza obutaba wano, obutatuula wano.
We may be at High Court Kampala.
Tuyinza okuba ku High Court e Kampala.
Now, if it is confirmed that we are not here,
Era bwe kinaakakasibwa nti tetuli wano,
it means Monday you will not find us here even if you come.
kitegeeza nti ku bbalaza temujja tusanga wano ne we munajja.
Now, if you don't find us here, find us at Kampala
Era
High Court,
bwe mutatusanga wano mutusange ku High Court e Kampala
Criminal Division.
ku Criminal Division.
It sits at City Square,
Etuula ku Minister Square
where there are 2 twin towers, Court of Appeal and Supreme Court, tall buildings.
awo wali ebizimbe ebiwanvu okuli kkooti ejulirwamu ne kkooti ensukkulumu.
But Criminal Division sits in the shorter building, the old one.
Naye Criminal Division yeetuula mu kizimbe ekikadde ekiriko ekimpi.
We have space which can accommodate all of you. There are bigger court halls.
Waliwo ekifo ekisobola okutuulamu mwenna kuba waliwo court room oba abantu mwe batuula kooti mwe ziwulirizibwa awanene.
So if you don't find us here, please come to Kampala.
Era bwe mutatusanga wano bambi mutusange e Kampala.
Thank you.
Mwebale nnyo.